Pardon to make a mention, my lord. My lord, one matter was before the lordship I had mentioned, and that was listed on Wednesday and could not reach. The lordship directed to list. Okay, and that is, my lord, the content proceeding is posted to Monday. Lord, kindly
Give them a.
Yeah.
Very pardon. It is a matter that the applicant filed OA challenging his transport order. Though notice has been issued in OA, but no stay order has been granted. Being aggrieved, he has filed the application. And in the writ also, High Court directed that the petition already relieved from service and no stay order has been granted. But notice has been issued. But evidently, he has not still continuing the Bhubaneswar. But matter is pending into 2023. Because of pendency of this writ application, the original application not taken up to the tribunal. That's why I filed a miscase orders that will be virtually it is invoked just this writ application.
An application challenging the judgment and order party part by a cutoff page where number 504 of 2019 urgent for financial loss and loss of age, so kindly respect.
Who are you? You are the person concerned. You will argue the matter.
Yes,
Yourself you will argue.
yes. Now, advocate or not, I sir, नोटिस दिया है किंतु चेंज है मिस एडवोकेट जो थिले आज माने नोटिस दिया हला पर बोले चेंज है मिस सेटा को बोले
No, if you want to argue the matter, you can argue, but you can take the assistance of the panel counsel in the legal aid panel counsel. There are so many advocates, and if you have to pay nothing to them. They are with counsel for this matter also. There are there. Once you apply to the legal aid, if you are eligible to get that, they will provide you.
फाइनेंशियल एफर्ट करी ना फाइनेंशियल एफर्ट है ना
पैसा दवा पड़ोनी
पड़ोनी पूरा बुझीपार ना पैसा दवा किसी पड़ोनी लीगल एड जो आमर हाईकोर्ट पैनल अच्छी लॉयर्स सर्विस मैटर करने काउंसिल अच्छा तेणु अप्रोच करूँ तो अप्रोच करते because you might not be so far as factual aspect with आपनो but when question would be put on legal side so just
तो मैं एलएलबी करछो
ना मु जॉब करछि
how can you say that
टेक्निकल जिंस गुडा का आंसर केमि दो
सर्विस मैटर
we cannot
document
give time आयु रामायण गपियों का मैं समय दे परिबन से टू दी पॉइंट कथा सार लीगल येटा कोन से माने हेल्प करी यू आर्ग्यू बट टेक द असिस्टेंस ऑफ द panel counsel. You have to pay no money, right? Yes, next.
I have to panel lordship. Item 10 in the list lordship. Item 10.
You come after the court hours and take the date. What is the date? But in the meantime, since you have come, go to the High Court legal services. Date you can get at 4 o'clock. Okay? Yes.
I have to panel in the list item 10 lordship. That is the challenging the order of the London Tribunal categories. I have not annexed that counter and subsequent documents. I have asked the Central District Tribunal for the certificate copy.
You want adjournment? Item number 10. You are for the petitioner?
Yes.
It has the okay, we have asked you to produce
If I have not received
the learning counsel for the petitioner. Take some more time to comply the order dated 26/25. Please this matter August. Yes.
Item number 6. Next to candidate.
Fourth time is seeking adjournment. There he is writing a letter to the legal magistrate not to take action because writ is pending. This is fourth time adjournment.
No, we have not granted any stay. So
My humble submission will not the lordship considered to clarify that pendency of the writ petition no power to
the
take
learning
any
counsel
action.
for the petition of 6 for an adjournment. Since no stay order has been granted, it is open to the opposite party number 2 to proceed. You have filed the section 14
Section
application
14 order has already been passed.
Uh,
Thereafter, a challenge here.
Proceed in accordance
to
with law.
proceed
With accordance
in
with law.
accordance with law. Yes.
Item 13, my lord, I beg your
ଆଉ
pardon.
ଏଇଟାକୁ adjourn କରିଦିଅନ୍ତୁ ଏଇ ଯୋଉ item number 6 ଟାକୁ adjourn କରିଦିଅନ୍ତୁ ଅଗଷ୍ଟ ରଖିଦିଅନ୍ତୁ again ଚାହିଁଲେ yes
Item 13, I beg your pardon.
yes
I pray, my lord, next week, my lord, on next Friday, if you coordinate the worship, my lord, I have to, that citation, I have to, often, fresh addition message.
land council for the এটা তো আসেনি মানে জমা press
Fresh, my lord.
land council for the petitioner fix for an adjournment give an adjournment fix a date yes
Permitting and so on. Applicant cost more than 11 years, my lord.
And item 14 permitted to withdraw with a liberty to move before the appropriate court.
लिखित
My lord, permit me to make a mention, my lords.
land council for the petitioner files a memo for withdrawal of the writ petition to move such other level and memo is taken on record disposed of as withdrawn giving leave. Yes.
My lord, permit me to make a mention, my lords. I'm the VC, my lords.
Yes.
Yes.
My lord, permit me to make a mention, my lords. My lords, item 37, my lords, I'm for the petition, my lords. My lords, can I pray subject to my lords' convenience if the matter will be taken up today, my lords? It's a matter where, my lords, the petitioners paid the auction purchase price 8 years ago, yet to get the property. This is the second round of litigation, man.
It's all right. The council is not here now, so we have to go serially. We hope that we can reach there. Yes, call the matter.
Grateful, my lords.
Supplement list, item number 1.
Delay on life and
302 life.
advocate admit for the advocate and use for the. That's the answer is. You see double repeat for them. Pura sincerely repeat for you. Yes, same now in item number 2 delay on one.
Item was delay about 10 years.
Whole of life confusion is admit. Call for this one so. Again, it are charging delay is delay on one same admit for you. Yes, next.
Item 4.
Like. Item number 4. Nobody is there for the appellant. And Milan Kumar is with some predominant counsel. Pass over to next.
Item 5.
Item 4 is pass over, man.
Yes, yes. Counsel for the petitioner is not here. Mr. Pai. Yes.
Item 5.
Opinion but TML not carry out the order annexed to
Have you handed over that consolidated writ petition to the?
already served.
Yes, what is your prayer here?
The opposite party number 2 is not carrying out the order under annexed to lordship passed by the London court, passed by the OP number 1 collector from district magistrate. Not handed over to the mortgage property to the petitioner lordship.
We are not executing court.
We are not here. Execute the, go to the, is not, go to the appropriate forum, not here.
Lordship already section.
It's all right, but we are not the, there are, if somebody is not obeying the order, the provision is there that where to approach and what is to be done. So he has already passed the order in your favor.
Lordship.
So then we are not here to.
Lordship, I have approached to the party number 3 lordship, but he is not carrying out.
Have you studied the Surface Area Act? That if an order is passed and that is not being carried out, then what remedy lies with the person concerned? And in this case, the person concerned is the financial company.
You proceed in accordance with law. But this is not the remedy.
Lordship, let it pass over Mr. My learned senior Mr. Rao.
No, this is the prayer. So you have, he has already passed the order. If you would not have passed the order, would have asked the Madam State Council he has asked the Superintendent of Police to deploy the adequate police force to maintain law and order. So the order is already in your favor. So what problem you have? How you are not getting that position? This order was passed on 16/1/2025. Annexure 2.
Lordship.
So see that
But Lordship, I have approached the and
How are you aggrieved by this order? This order is in your favor.
this is not against you. This is in your favor. So
but-
now you want that we will execute, we will direct the Superintendent of Police. You go and seek the alternate, the remedy which is available under law. We are not here to execute the order of the District Magistrate and Collector Puri. Is it your case that the Superintendent of Police has not taken follow-up action?
Lordship.
So you have to go to the appropriate remedy.
Lordship, let it pass over Lordship.
No, we will
Take
give that.
interest
The petitioner has filed the writ petition with the prayer for a direction to the opposite party number 2 and 3 to ensure the handing over of physical possession of the mortgage property under Annexure 2 within a stipulated time. It appears that the District Magistrate and Collector Puri under Annexure 2 has already passed the order dated 16/1/2025 in favor of the petitioner and directing the Superintendent of Police to deploy adequate police personnel to maintain law and order at the time of taking over the possession of the secured asset of the default borrower. Stop. If it is the case of the petitioner that the order is not being carried out by the Superintendent of Police, the remedy lies elsewhere, but not before this court, and this court is not the executing court. Accordingly, it is open to the petitioner to seek appropriate remedy in accordance with law. Writ petition is disposed of. Yes.
Pardon, my Lordship, let me pass over Mr. Rao till after this matter. So it's
Yes.
We will record his name off.
Item 4, madam, pardon, madam, withdraw the but to have a retribution.
File a memo.
My lord, madam,
For the petition of file.
I'm giving my.
Mr. Swine, to withdraw the writ petition, disposed of has withdrawn.
No, liberty, madam.
See, তাদের লেখুন।
Like liberty. Maybe give
দিয়ে দিয়েছেন, memo দিয়েছেন? Yes.
better petition.
Yes. Liberty granted, yes. Next.
Item
Okay.
7.
So you will support to produce the review petition and also the entire order sheet. This is the direction to this also to dispose of 2020 review petition. ଆପଣ କଣ apply କଲେନି? ମିଳୁନି? The Learning Council for the petitioner seeks some more time to produce the copy of the review petition, so also the certified copy of the entire order sheet of the said review petition as per the order dated 26/2025. List this matter. Yes.
Item 8.
Writes a memo to withdraw the writ petition disposed of as withdrawn. Liberty is necessary, not necessary. All right.
Item 9.
And I'm for the opposite party.
Yes, Union of India.
Could you kindly pass over or adjourn from other days?
Mr.
Devdas is appearing in this case.
No, it's all right, but where is he?
Kindly pass over.
Pass over, okay. Yes,
Item 11.
SK Naik 2. Next,
Item 12.
Section 14 applications are pending before the opposite party number 1 since 2023. The election may be ended there.
so let him obtain the status. You obtain the status. This,
21st.
huh?
Huh?
This writ petition has been filed by so for a direction to the opposite party number 1, Collector and District Magistrate Khurda, for early disposal of or tinita account ye
3 applications, ma'am.
tinita ye pai apun gotte kendi file karibe writ re ha tinita separate asset heitibo tinita separate case heitibo gotte kendi writ file korchandi you withdraw it, file a better application. The learned counsel for the petition of 6th permission to withdraw this application to file a better application. Dispose of file to withdraw. Yes, yes.
Item?
Item 11.
Yes, item 11.
May it is a loss. I'm challenging the e-auction notice passed by the Bank of India by the annexer to my humble submission before your lordship. I mortgaged a loan, but I obtained a house loan by mortgaging.
13 for notice issued and date was fixed to 27/5/2025. What happened on that day?
No auction till now, no auction.
So you approach the bank or the take alternative remedy.
The bank has already initiated a case
You have
against
to,
me.
you have to challenge those things before DRT.
Look, this writ petition has been filed by the petitioner challenging the e-auction sale notice as for dated 9/5/2025 under annexure 2 issued by so. Also, decisions would have put alternative remedies available. Disposal. Yes.
Item 15.
The petitioner has been removed from service on the ground of conviction in a criminal case. That was challenged before the learned cat. That has been dismissed.
Conviction stands.
Conviction, I have filed appeal that stands. The petitioner conviction.
So, what can be done?
Yes, your lordship will consider, because my submission is that he has not considered, the authority has not considered conduct leading to the conviction. Only on the basis of conviction, he has punished. And the so-called notice and punishment, both were served when the petitioner was in jail. On 38/11/38/22, he was convicted, he was in jail.
But what is the offense for which you are found guilty?
Offense 306, 304B, 498A. He is not the husband. He is the husband, sister's husband.
No, whatever it may be. So, what is the sentence?
Consider whether the conduct leading to the conviction has been considered or
Where
not.
is, so as the notice?
Notice annexure 1, page 12.
The notice itself will disclose.
He has given the conviction. I was in jail during that period. The so-called notice was served when I was in jail. The punishment was served when I was in jail. So I was not granted proper opportunity to refer.
The conviction leading to principle
My lord.
will apply before the conviction. Once the conviction goes, the presumption of innocence goes. So your conduct is leading to conviction. It's
No, that has to be considered by the authority.
when the
Section
when the
19.
trial is pending, that principle can be employed.
No, my lord.
Yes.
Once you are found guilty,
Guilty,
and
then that principle goes.
If you
No.
succeed in staying,
Your lordship may kindly,
Unless your conviction is
your
stayed.
lordship may kindly take into consideration section 19.
no, any order has been passed, staying the conviction order,
No,
then
no, conviction itself, my lord, the law is conviction,
Conviction is not
conduct
enough.
leading to conviction.
But
Conduct leading to conviction. So he has to consider the conduct, not the conviction. The authority, disciplinary authority has to consider the conduct leading to conviction. That is,
that's what we are saying. If conviction is already there,
Yes,
the question of leading to
That
doesn't arise.
No, he has to consider the conduct. That is Tulsiram Patel case. If your lordship says, I will reduce that also. But that is the law, and the rule itself says.
so Mr. Pujari, do you mean to say that if in relation to an service matter only, if he is found guilty, then if it is outside the service matter, even if your personal life,
I don't
you
mean to say.
then-
What I mean to say,
you will commit a murder. In this case, the 306 is there.
my,
So torture and
my lord, rule 19 of the.
No, come to page 13. Page 13.
Yes,
In the last paragraph.
my lord,
Whereas undersigned.
my lord.
Whereas undersigned
Capacity of the
is of the view that owing to the gravity of charges,
gravity.
that is the leading to conviction.
That judgment was not there before him.
no,
He must.
Gravity of charges.
He has not considered he has not taken into consideration the judgment.
in the
That-
very previous paragraph, he has mentioned that he has been found guilty under what offenses and what
I don't-
sentence. How do you say that
I-
it was not there?
That
Then
I don't dispute that, but the question is the provision says whether the penalty is imputed in a government servant on the ground of conduct which has led to.
in what,
Conduct is gravity of charges.
in what way he has
Gravity of charges.
Rule 19(1) of the CCA rules.
That's right.
And that is the provision in Article 311 of 2 of the Constitution also. This rule has been
you
incorporated.
try your luck there, and
No,
if you get then that in the criminal appeal, the
appeal is there. And he has been granted bail on the.
bail is not the, we are asking you about the stay of conviction. That is suspension of conviction and grant of bail is different than stay.
I do admit.
So apply that and take your chance there. And if you get that, then you can apply for.
Your
it has been
lordship,
stayed. Once that order is received, once that order is you get it, then it will be said that as if there is no conviction. Then the authority may consider your case. Otherwise, once you are found guilty,
my lord, your lordship will kindly consider during the notice and during the imposition of punishment, I was in jail. So I sought time that was never granted.
it's not. It is just on the basis of that conviction judgment you have been dismissed because they might have placed you under orders of detention.
The authority has to consider what is the conduct which led to conviction.
Conduct is the grave charges.
Your lordship may call it on any other day. I will call
The
it.
Land and Council for the petitioner 6 for an adjournment. Keep it.
Get some judgment if you can.
My lord,
To cite some petitions. August month.
Item 16.
Our appearance may be noted by Lord.
Mr. Pari, Athana likhiwa ho?
Samantara, yes, Samantara.
Yes, Manoj. Yes.
And item 16, you know. This is a single bench matter. When you lordship of glance annex 13, on similar cause of action similarly suited to employees.
ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି କୋଉ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
My lord,
ଟ୍ରାଇବୁନାଲ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
no, that is the annexer impugned order is annexer 12, that is the order of the state government, my lord. Here a case, my lord,
you see your prayer, how many prayers you have made.
actually,
Suppose one of the prayer relates to the division bench, and other prayers relate to the single bench, that it would be placed before the division bench.
So my respectful submission, my lord.
If you exclude the other prayers
My lord.
and confine the prayer only to one which is under the jurisdiction of the single judge, matter is different.
Kind
But
of-
once you are challenging the order of the Land and Central
My-
Administrative Tribunal,
My
how
lord.
it will go to the single bench?
Just I would like to draw your lordship's attention. Please have a glance annexure 13, my lord. 13 page, my lord, 112, my lord. Where is it? Honorable court.
No, no, it might be, he might have, the honorable judge might have, but question is that whether against the order of the Land and Central Administrative Tribunal, the matter is to be challenged before the division bench or a single bench.
So my respectful to prayer, my lord, whereas the identical matter earlier passed order, my lord.
That's not-
So, and referring to
exam-
that case, my lord,
That is
I-
already, in that very decision, it has been stated like this, it is to be had with, it's not.
My lord,
you
ju-
think so.
just I would like to draw.
Whether you want to argue the matter on merit or you want adjournment, you tell us.
And
Don't ask us.
my humble prayer, my lord, let the matter be taken up before single bench.
No,
because-
we cannot pass.
Why are you interested in single bench or double bench?
Will not pass that order.
Because
Argue the matter.
two cases orders are there, my lord.
Yes, yes. Argue the matter on merit, otherwise will
Yes.
not pass that order.
Yes, I will argue on point, my lord.
Yes.
My respectful submission, my lord, the factual matrix of this case is that
What you are challenging now?
I am challenging the impugned order under annexure 12, my lord.
Yeah.
It is first order because referring to the order of
No,
the
2018 order, why are you challenging before us?
my lord,
2018 order, what you are doing since 2018?
because my lord, the contractual implies that.
Have you not gone to the Central Administrative Tribunal against this order?
Yes, my lord.
Then
Because,
what is that? You come to the Central Administrative
Yes, my
Tribunal.
lord. Can you lordship glance first order of tribunal under annexure 2, my lord,
Yeah,
page 27.
yeah. That
Page
is
27, my
That
lord.
is 2012. Come to the latest one.
Latest one is, my lord, under annexure 9, my lord.
Yeah.
So, London Tribunal passed such a order, my lord, where the real suppressing the real gravity of the case, the London Tribunal has passed order under annexure 9, my lord. In that case, my lord, the contractual implies those those brought under regular establishment at belated stage, they got prospective benefits of the promotion. Now they are continuing and got 3 promotion, my lord, from forester to deputy.
In this year, you are a petitioner.
At that time, I was not employed as a party, my lord. Whereas the tribunal,
Have you approached the tribunal at that point of time?
no, I have not approached. The contractual employees, they have approached before the tribunal.
Then how it goes against you?
That is, we are the direct recruitee under annexure, pursuant to annexure 1, my lord.
Yeah.
Because advertisement issued under annexure 1, whereas we have participated in a transparent selection procedure and we have directly appointed as a forester in the year 2011, my lord, under page 26, my lord. So, whereas in the meanwhile, our service has been utilized by the state government for a prolonged period of 15 years, but we are continuing in the same position as a forester. Whereas, my lord, under annexure 12, the contractual employee, they brought under regular establishment in the year 2017-18 like
You
this.
are approaching this court for the first time.
My lord.
You have not gone to the Odisha Administrative Tribunal earlier.
No.
You are approaching this court for the first time for regularization of your services.
No,
Then-
I have not approached for regulation. We are the direct recruitee, my lord. Where the contractual employees, those of no local standing, now they have got 3 promotion, my lord. Now forester to deputy ranger to forest ranger, and forest ranger to SCO, my lord. Whereas, consequent upon the faulty order of the tribunal under annexure 9, the government has also given such benefits to them, whereas we are the direct recruited employee, and we have participated through a transparent selection.
Why so many persons have, that is their individual grievances, so why they have joined together?
My lord.
Why they are the petitioners here? It's if you claim the promotion,
My lord.
so you have individually approached this court.
My lord.
Why so many persons joined together? The cases might be distinguished from one to other.
No, my lord, under annexure 9, my lord,
The tribunal, the
You
contractual.
tell us one thing, when this matter was pending before tribunal, you knew this matter was pending. Why have you not got yourself
We are
implicated?
not implicated as a necessary party into the OM law.
When did you come to know about this proceeding?
After getting, while the contractual employee got 3 promotion, but we are in same position as a forester, such a action, my lord, we have approached. Yes, sir, everything I paid, my lord.
No. It's an individual
But
action.
my humble prayer, my lord, kindly lost my
Not
plans
paid.
for a moment.
Not paid for the extra court fees.
extra court fee ଦେଇଛନ୍ତି ନା
Extra copy, sir, ମୁଁ ଦେଇନି ଗୋଟେ ଅଛି।
Extra copy ନୁହେଁ ଆଜ୍ଞା।
Court
କଣ
fee.
କହୁଛୁ କଣ?
Court fee I have paid.
ଆପଣ କେତେ ଟଙ୍କା ଦେଇଛନ୍ତି ଦେଖନ୍ତୁ ସେଠି ସେ ଏସ୍ଆର୍ ଯୋଉଟା ବସିଛନ୍ତି ଦେଖିନାହାନ୍ତି ଭଲ
ସେ 22 ଜଣରୁ ଲେଡିସ୍ ଅଛନ୍ତି, ଲେଡିସ୍ କୁ ଏକ୍ସେମ୍ପଟେଡ୍ ହେଇକିରି ଆଉ ଯାହା ରହିଲା ମୁଁ ଦେଇଦେଇଛି।
ଆପଣଙ୍କ ଟୋଟାଲ ଆଦେରେ ଲେଖା ହେଇଛି 20, 20, 40, 60, 10, 70 ଆଉ 70, 75 ଆଉ ଏଇଟା ଯୋଉଟା ଜଣକ ପାଇଁ ଆଦେରେ ତ ଗୁଡାଏ ଲୋକ ଅଛନ୍ତି ଯୋଉମାନେ କି ମେଲ୍ ପର୍ସନ ଅଛନ୍ତି। How do you say that you have paid
Female persons they have exempted some court fee, but for ଆଉ ଯୋଉ ରେଷ୍ଟ ଯୋଉମାନେ ଜେଣ୍ଟସ୍ ଅଛନ୍ତି ମୁଁ ତାଙ୍କୁ ଦେଇଦେଇଛି। To that effect no stamp reporting, nothing.
Stamp reporting ଆମେ ଜାଣୁଛୁ କୋଉ ଟାଇପର ହଉଛି stamp report. Let them examine again. The writ petition has been filed by 22 petitioners seeking for several reliefs. The Land and Council for the petitioner shall satisfy this court as to why separate writ petition has not been filed by the petitioners for this said relief, and the stamp reporter shall submit a report as to whether the appropriate court fees has been paid, since the petitioners have joined together to challenge various orders, put up this matter on such and such date with the report of the stamp reporter. Yes. Wait.
Item 17.
Item 17 actually, so the last myself who have entered appearance, because we have been made parties. So if you can serve a copy, it can be taken up on Monday.
Your for section 14 application is pending.
Is pending before the CJ.
What is the status of this? Take the instruction.
I have given the certified copy of the order, last order. It has been posted to 11/7 for further hearing.
Okay.
Is hearing the matter, though the law settled question is that it will only adjudicated on the basis of the affidavit filed by the bank.
Affidavit also, because I have been made party
No,
here.
it's all right. We are taking in similar matters, we are taking just instruction about this.
Yes.
21st.
Petitioner has filed this writ petition for a direction to the opposite party to dispose of criminal miscase number 229 of 2024.
Opposite part number 2, man.
Opposite party number 2, that is
CJM.
Chief Judicial Magistrate Cuttack. For disposal of within a stipulated time by directing deputing the police force and executive magistrate commissioner by fixing a date for taking physical possession of the secured asset. The Land Council for the petitioner submits that even though the case was instituted in the year 2024, it is urgent from time to time, and now it is posted to 11/7/2025 for further hearing of the petition, further hearing. Let a report be called for from the land CJM from Chief Judicial Magistrate Cuttack in criminal miscase number 229 of 2024 as to why there is delay in disposal of such petition, even though there is period specified under the statute for disposal of such application. Stop. Mr. S.Mishra and senior advocate submits that he has instruction to appear for
Already appeared
for opposite parties number
3 to 6.
3 to 6. Put up this matter in the week commencing from 28th of July 2025.
I have already started a copy on it.
Acha, let a copy of the copy of the writ petition has already been served on the land council for the opposite party number 3 to 6. Let the file be placed before the land and registered judicial who shall send email to the land Chief Judicial Magistrate Cuttack to obtain the report. Through email. That will the report be placed in this launch on 28th of July. Yes, next.
I can just put one word or what question is there. Yours must be aware of it. That the time that has been fixed for disposal
Yes.
is not mandatory, it's directed.
All right.
That's a direct Supreme Court.
Yes, next.
That
Item 18.
That challenge the order of law is Kendrapada. On a petition under section 14 of the Federation Act, in which notice has not been issued to me and direction was given. Notice had not been issued to me. I am the borrower.
Go raise those points before borrower alternative remedy is available.
No, my remedy that in debt recovery tribunal case is pending, my lord, for adjudication.
is
No, no.
pending, man.
That is pending. Now, my lord,
Move application.
Move application, early disposal.
they have directed to take possession of this.
Yes,
my lord, physical possession. No notice
No,
had
no.
issued by.
Sale notice was issued,
My
my
lord.
lord, that sale notice failed.
My lord,
So, no sale notice.
notice has only that no
Yes, has not been.
opportunity of being had has been provided in this case.
No, now, Mr. Mahathi, admittedly, you also admit that the matter is sub judice before the
Debt recovery tribunal. But here, my lord, that they have not given me the opportunity of being had, my lord.
Where?
In this case, my lord, miscase number 12 of 2025.
No.
Annex 7, my lord.
That's a different matter. You ask the matter, that order, you can take it from there.
If
not-
the natural justice has been violated, my lord.
Go there and ask
my
you.
lord.
Yes, alleged, my lord, the bank has taken just a symbolical position.
No,
Alleged
my
that
lord, what
35
happened, my lord? One year, the case of-
We are not entered.
I don't want to work on merit, my lord. Only one point, my lord. Without notice, can CJM pass an order, my lord?
No, go and tell the other authority who is in session over the matter that this is going on, and so that order can, why we'll pass that order. That is the only limited thing we are asking you. That we're making it clear. The petition has been filed for a direction to the opposite party number 2. 2 came.
No, my lord.
Where is the CGM you have?
No, opposite by 1 mile.
Opposite party number 1.
CJM Kendrapada. Annex 7 mile.
ଆପଣ ଏଠି ଏଟା କେତେ ନମ୍ବର ମ୍ୟାଟରଟା 1903 ଆପଣ ତ 1 ନମ୍ବର କରିଛନ୍ତି ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 1 ହଉଛି କାନାଡା ବ୍ୟାଙ୍କ
Canara Bank. Canara filed the petition under section 14, my lord.
what is your prayer here
Here, my lord, that the section 14.
passing the order of the order dated 8/5/25
Yes, my lord. Of Lawrence CJM Kendrapada. Under section 14.
the writ petition has been filed to pass the order dated so and so of the land and Chief Judicial Magistrate Kendrapada in miscase number so and so, in which while disposing of the miscase number 12 of 2025 filed by the Canada Bank under section 14(1) of the SAFESI Act, the land tribunal has held as follows: court the operating partner. Since in view of the decision so and so, alternative remedy is available to the petitioner, and it is stated at the bar that the debt recovery tribunal is in session over the matter. Can you tell me the number of that? SA number?
Case number.
SA 28 of 2025.
SA 28 of
2025.
2025. It is open to the petitioner to take appropriate step in the said matter. We are not expressing any opinion on the merits of this order which are challenged before us. Accordingly, the writ petition is disposed of. Yes. Beyond the name,
The certified copy on annexure may be.
the certified copy under annexure 7 be returned to the land council for the petitioner on being substituted to the Xerox copy, Xerox 2 copy. Yes, next.
Item 19.
Yes, Mr. Bhokta.
Item 19. Here I'm uploading a writ application. I'm serving a copy of the writ application today also.
Since the land council for the so and so has already entered appearance for the opposite party number, sole opposite party by filing wakalatnama, we let the land council for the petitioners. The land council for the petitioners saw a copy of the writ petition on the land council for the opposite party number, opposite party. When you want both of you?
Next week.
Next week.
It's my information. In this case, Mr. Abhay Kumar Behera, senior advocate of Supreme Court, will appear.
କେବେ ରଖିବା କୁହନ୍ତୁ ଆପଣ କାଲି
22 ନଅ
22 ରେ ହେଇପାରିବନି ସେ ମଙ୍ଗଳବାର
I see no long distance because he has filed a contempt application against the order of
night I have discussed with
it is his petition. We cannot adjourn we have not yet issued notice. You have so much to entered appearance. So whether we will
I will file my counter, my lord.
no, we have not issued notice where it is filing counter affidavit. It may be dismissed also. Who knows? So let that stage come and the senior counsel will be there. But at this stage, why you want you have filed?
Appear online also. What is
online? So many counsel are appearing through virtual mode. Let them appear and for we have not yet issued notice. You have so much appeared. Let that stage be over first.
Yes.
Then you file your counter affidavit and we'll hear the land council. So we'll take up this matter. You want next week?
next week 28.
28 first. Put up as prayed for by the land council for the petition. Raise this matter on 28th July 2025. Yes.
Item 20.
Yes. Petitioner is the option purchaser, followed by confirmation of sale under annexure 9 of the year 2012. Your lordship have a blank space 30.
What happened now?
Now, Lord, delivery of possession has not been to the option purchaser, for which he approached this honorable court. This honorable court has been pleased to direct the petitioner to approach the DRT. And it is thereafter petitioner approached DRT and that application was rejected under annexure 1.
That is against the order of that DRT you are approaching us.
Yes, you are.
And you are leaving one appellate forum. Why will entertain this? Have you not got the alternative remedy with you to approach DRT?
So far as the claim of the petitioner.
No, Jahabi who you are aggrieved by the order of the land and debt recovery tribunal, right? So you have got the remedy. We are giving you liberty, and that was rejected only on the ground that 7 years delay by the auction purchaser. Now again you are making the delay by not going to the appropriate forum coming here.
So far as delay is
What is the
concerned,
period for approaching that? Thank you.
This period is available. The Lordship have glance rule 9.
No, no, about the DR. appeal କରିବା ପାଇଁ order କେତେ ସମୟ ଅଛି? 60 days. Appeal to appellate tribunal, any person aggrieved by any order made by the debt recovery tribunal may prefer an appeal within a period of 30 days, provided that no appeal is filed unless one so provide also appellate for the reasons to deport. So 14 days. So now, the petitioner is aggrieved by the order dated keep the passage 21/6/2025 passed by the London Debt Recovery Tribunal Qatar in RC number 103/2007/CTC. Since the petitioner has got alternative remedy to challenge such order under section 18 of the Surface Act 2002, we are not inclined to entertain this petition. The petitioner is at liberty to oppose the appropriate form. Accordingly, the petition is dispensed of. Yes.
Item 21.
Item 21, my lord. Similar matter arising out of the same order pending before this honorable court, that is WPC number 2337/25. That is the lead case. This case may be tagged to the other case, my lord.
Have you got the order sheet of that?
Order sheet, my lord, it is online available. I don't
No, WPC form done bhar.
WPC number 2327/25.
2327 of
25.
a bhar karo tik 2327 of 25. Here you are challenging the order dated 14/12/2003.
Yes, my lord.
Passed in way number 568 of 2017. Same order is challenged there also.
Yes, my lord.
Same impugn order.
Same input order.
Take dekh raha.
A common order.
Annexure 1.
Annexure 1 is the input order.
Achha.
I am challenging 568. They are in the other writ application 528/17 was challenged.
Take just a minute.
And some orders have been passed, the matter is
back pratham order to that. Order number 4. First order to that. Order. Challenging the order dated 14/12/2023 passed in way number 570. Okay, 570 अच्छी तरह हाँ कौन order है इसी तरह 500 सब रहे गौड़े आनंद Mr. Maral and Councillor appearing for the submit that the said WPC which was filed by Union of India is dismissed by this court. However, the Union of India has approved the Honorable Supreme Court and SLP sub judice and their an order of stay of operation of the order passed without cash. Listen, the Land Council for the petitioners submits that against the self-same order which is challenged in this writ petition, another writ petition by WPC number 2327 of 2025 is sub judice before this court, and the matter may be listed with the said writ petition. List this matter with WPC number 2327 of 2025. Yes.
Item 22.
Appeal balance. Number का ठीक लिख देता हूँ 2323 और 2025 है ना
May I please have it?
Yeah.
Allots East Coast Railway Administration took a decision which is available at page 55. At page 55, your lordship may kindly see. Took a decision to transfer assistant loco pilots from Khurda Road Division to Alternate Division on the ground.
You are the counsel for the Union of India, no?
I was, sir.
You are.
I was. Now I am a counsel for the
All
state
right.
of Odisha.
No, it's all right. Yes, but
East
yes,
Coast Railway Administration took a decision to transfer assistant loco pilots from Khurda Road Division to Alternate Division on the ground. Alleged ground that there is shortfall of ALPs in Alternate Division, surplus ALPs in the Khurda Division. Which
you
is
are
not a-
challenging the order dated 16/7/2025, passed in MA number or what?
Yes, I approached the Central Tribunal. Since I did, as Honorable Central Administrative Tribunal, while issuing notice, didn't grant me the interim order. That is how I am before the process. I'll come to that order.
No, you see that order
Yes, sir.
dated 16/7/2025.
Yes, my lord.
And in the last sentence, in fact, paragraph number 6, it is mentioned that list this matter on 31/7/25 for giving consideration to the prayer for interim relief as prayed for. So that is pending. How you have come here?
This is a transfer matter.
ଆପଣଙ୍କର interim relief जो prayer କରିଛନ୍ତି ସେଟା 31/7/2025 ରେ consider କରିବା ପାଇଁ ଅଛି।
That will be in
ଆପଣ ଯଦି urgency ଅଛି ତାହେଲେ ତାକୁ କରନ୍ତୁ ସେ date କୁ ଆଉ ଟିକେ advance କରିବେ। ଏଠି କଣ ପଳେଇଲେ ପୁଣି ସେ order ଟାକୁ challenge କରିବେ।
ଟିକେ ସାର୍ ଏଟା ଦେଖିଲେ ଯୋଉ ଆପଣ entire interim order why it was not passed. He has taken the.
But all the same, he has kept it for consideration. He has not rejected your prayer.
Correct, my lord. He has not rejected.
Now we will issue notice, they'll come and it will be beyond 31st. Better that you go and press there.
Your lordship, I am proposing subject to lordship's acceptance. So lordship can remand the matter to them, saying that
What will we remand? Already there pending.
Already there.
pending for reconsideration. Because
We will simply say that we expect that the matter will be heard on 31st/7.
31st, I understand, my lord.
That much will
This
say.
petition has been filed
By
already.
tomorrow they will relieve.
It's challenging the
So,
order
big
dated
process.
16/7 inter alia लिख दूँ inter alia date order dated 16/7/2025 passed by the London Central Administrative Tribunal in OA number 312 of 2025 under Annexure 11. On perusal of Annexure 11, it shows that the interim relief sought for by the petitioner in the OA is posted to 31/7/2025 for consideration. In such view of the matter, entertaining this writ petition would not be proper and justified. It is open to the petitioner to
If any urgency is there.
if any urgency is there, it is open to the petitioner to file appropriate application for advancing the date to take up the matter for interim relief. And we expect that the Land Central Administrative Tribunal, in view of the urgency of the matter, the Central Administrative Tribunal shall pass necessary order. Yes, this.
Our name may be reflected, ma'am. Madam, our name may be reflected, ma'am.
कहाँ ना कुंदु?
Amit Kumar Shah along with BSJ, ma'am.
Amit Kumar
Shah, madam.
ଆପଣଙ୍କୁ କେହି ନାହାନ୍ତି ଲେଖିକି ଦେଇ ଦିଅନ୍ତୁ କାହା କାହା ନାଁ ରହିବ। Yes.
But in future, my lord, such
But you got everything.
Yes,
I was saying, my lord, it would be helpful for all times to come. Section 24 defer question. Section 24 is not applicable here.
Item next item
Item
24.
23.
Item 9.
9 out of 5 over. Yeah,
Pass over item number 9.
Well, the petitioner challenging the order passed by the London Central Administrative Tribunal Cuttack with Cuttack under Annex 5. Running page number 22. So come to the page
Not my copy.
25.
OA, nothing. Where is the copy of OA? Have you filed?
Yes, my lord, I have already filed.
Okay.
Well, come to the page 25.
just a minute. We have not issued notice in the matter, but they have entered suo moto. Right? Yeah.
Yes, ma'am.
What is your prayer in this? Which order you are challenging?
Order Annexure 5.
Annexure 5. So
The order.
that was filed by the opposite party.
Yes, my lord.
So what relief you are seeking for in the before the London Central Administrative Tribunal?
My lord, the brief of the fact is that the petitioner was appointed as a.
You come to the paragraph number that 1 of that order, impugned order, where the prayer has been quoted, the relief sought for by the opposite party has been quoted there.
Yes, my lord. The applicant challenging the order dated 31/5/2023 issued by the respondent number 3 has filed this OA paying for following reliefs. To quash the observation of letter dated 31/5/2023 issued by the respondent number 3, while added to respondent number 2 to the extent that the applicant has not completed 10 years of qualifying service and not entitled for pension. Roman 2. To direct the respondent to count the past service of the applicant with the effect from 13/6/1982 to 39/2006 for the purpose of pension and other pensioner benefits. To direct the respondent to sanction and disperse the authorization of service gratuity in favor of the applicant forthwith.
What is shortfall? How much time is shortfall? 3 months. Come to para 6.
Yes.
Yes, there are Supreme Court judgment on that effect. Page 24, para 6.
Yes. As per the rule 3 of the 49 CCS and pension rule 1972, in calculating the length of qualifying service, fraction of a year equal to 3 months and above shall be treated as a completed 1/2 year and a reckoned as qualifying service. In the instance case, the applicant had completed 9 years and 10 months. Therefore, applying the rules, since the applicant had completed 10 months.
9 years, 10 months he has completed.
Yes. No,
shortfall of 2 months.
Actually, my lord, the petitioner is not completed.
And he is now 70 years. The court has recorded all this thing. You are harassing the.
My lord, kindly go.
Our जो भलो matter गुड़ा कर इको ना यही सब matter गुड़ा कार कौन है चीज़ है.
As a similar matter, already this
any order passed against you.
Why unnecessary harassment?
Similar footing matter. My lord, I have given the number to my lord. My lord, kindly see.
He is 73 years man, and he was in service from 1980 or something. He was
initially in 80 joined.
1980 मसीहारू चाकरी करी रिटायर्ड हेलानी ता पचर लागछन आपण.
नहीं आमे लागी.
नहीं आमर कोन लगे ये तो कोन. Listen, this writ petition has been filed by the petitioners challenging the order dated 2/1/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00465 of 2023. The opposite party, Nepal Harijan, approached the London Central Administrative Tribunal in the aforesaid way with the following prayers. Quote, the prayer has been mentioned in paragraph number 1. After issuance of notice, the petitioners appeared in the said case and filed their counter affidavit. The London Tribunal, after considering Sub-Rule 3 of Rule 49 of the CCS Pension Rule 1972, has been pleased to allow the original application. The relevant portion of the impugned order 678 are quoted here in the quote 678. After going through the impugned order and hearing the London Council for both the parties, we find that the London Tribunal is quite justified in applying the said provision and allowing the prayer of the opposite party. We find, moreover, the petitioner is now, opposite party is now aged about 73 years, and he started his service as work charge Khalasi on 6/5/1980, and thereafter he
joined on 13/6/80.
Thereafter he joined temporary basis on 3/6/1980 लिखा है जी। 3/6/1980
appointed.
अच्छा, appointment letter was issued on 3/6/1980 and he submitted the joining letter on 13/6/1980, है ना? And he was regularized on 16/5/2007, है ना? Accordingly, we find no perversity or illegality in the impugned order and same is liable to be dismissed as. Yes, next.
Now, there is a circular.
Yes, yes. Next item number.
Item 23.
Maybe.
Obligement.
23.
The conviction.
Prisoner's petition has come. Mr. Chand, you have filed your wakalatnama. Prisoner's petition ଆପଣଙ୍କ ନାଁରେ ଅଛି ନା ଅନ୍ୟ କାଉନସିଲ ଥିଲେ? You have to file wakalatnama. How can we?
Because I'll check it up and I'll give.
There is no wakalatnama. File କରନ୍ତୁ।
2 weeks after. 2 weeks after.
ଲେଖନ୍ତୁ। Prisoner's petition has been received for engagement of Mr. Manas Chand. Mr. Chand submits that he may be given 2 weeks time to file wakalatnama for the appellant. Put up this matter in the week commencing from 4th of August 2025. If Mr. Chand files the wakalatnama in the meantime, the names of other counsel shall not be reflected in the cause list. Yes, next.
Item 24.
Item 24. Day before yesterday, I filed power on behalf of informant. I request my senior to supply a copy of the appeal memorandum. It has been filed electronically. And that friend supplies his email.
All right.
Yes, yes.
Next week as you.
No, let it come a week after. Next week I mean.
काका नारे वकालतनामा ची समस्त नारा दे दूं. So also submits that he has filed a wakalatnama for the informant.
Yes, sir.
On Quebec file कर देंगे.
Day before yesterday.
Day before yesterday.
It was on that is it.
अजियल आउट करो मैंने 16 तारीख फाइल कर देंगे. 16th of July 2025. Let the registry place the same on record and the name of the land counsel for the informant be reflected in the clause list. The land counsel for the appellant shall supply the copy of the appeal memo to the land counsel for the informant with the copy of the interim application.
Let him give me his email address.
The land counsel for the Mr. Pandas, land counsel for the appellant submit that the matter may be taken up after 1 week. It is this matter in the week commencing from 28th of July 2025. Yes.
One more prayer.
Yes.
Custody certificate.
In the meantime, the land counsel for the state shall obtain the custody certificate number 1, the criminal antecedent, if any, again the appellant and his conduct inside the jail. Yes.
And evidence copy. Everything is there. The copy has been supplied. High Court records are there, sir. This is an electronically filed.
ଆପଣ ये पेन ड्राइव रे बारंबार କୁହାଉଛି ଆପଣ पेन ड्राइव ରେ ନଉନାହାନ୍ତି କାହିଁ ସେ ସେଗୁଡାକ ଦେବେ ଆପଣ ସବୁ ତ ଆଭେଲେबଲ ଅଛି ଲେଖନ୍ତୁ if the land counsel for the land counsel for the state submit that he may be supplied with the deposition copies. The registry shall supply him the deposition copies in his pen drive, है ना? Yes, next.
Item 25.
May please, Your Lordship. Item number 25, my lord. The present appellant sentenced to undergo imprisonment for life and to pay a fine of ₹10,000 under 302 of IPC, Your Lordship. To prove the case of prosecution, my lord.
Just a minute. You have got the deposition copies.
Yes, sir.
Yes, Your Lordship. The TCR is also available.
It is coming for the first time.
First time, Your Lordship.
Okay. So your conviction is under section
302 of IPC, Your Lordship.
Okay. So is it a case of direct evidence or circumstantial
No,
evidence?
my lord, dying declaration only there, Your Lordship.
Okay. Who are you?
I'm
Father-in-law,
Your Lordship. Father-in-law of the deceased.
Well, who is the recorded the dying declaration?
PW7.
PW7
He's the
PW7 is the
executive lodge.
PW7
Executive magistrate.
executive magistrate. And that dying declaration has been marked as exhibit
Exhibit 5, Your Lordship.
5. Come to that. ତୁମର ନାମ ଠିକଣା କଣ? ମୋ ନାଁ ଲିପିକା ମହାରଣା। ଶୁଣଛୁ ତୁମ ଦେହ କିପରି ପୋଡ଼ିଲା? ଗତକାଲି ସକାଳ ପ୍ରାୟ 8ଟା ବେଳେ ମୋ ଶ୍ୱଶୁର ମୋ ସାଙ୍ଗରେ ପାଟିତୁଣ୍ଡ ହେଲା। ଶ୍ୱଶୁର ମୋତେ ହାଣିବାକୁ ଆସିବାରୁ ମୁଁ ପେଲିଦେଲି। ତାପରେ ଶ୍ୱଶୁର କିରୋସିନ ଢାଳି ନିଆଁ ଲଗାଇଦେଲେ। ମୋ ଶାଶୁ ନଣନ୍ଦ ମୋତେ ଧରିଥିଲେ। ମୋ ସ୍ୱାମୀ ଗାଧୋଉଥିଲେ। ସେ ଦୌଡ଼ି ଆସି ମୋତେ ମାଡ଼ି ବସି ନିଆଁ ଲିଭାଇବାକୁ ଚେଷ୍ଟା କରିବାରୁ ତାଙ୍କ ହାତ ପୋଡ଼ିଯାଇଛି। ମୋ ସ୍ୱାମୀ ଭଲ, ମୋ ଶ୍ୱଶୁର, ଶାଶୁ ଓ ନଣନ୍ଦ ଦାୟୀ। ହଁ, କ'ଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି?
My lord, while dying declaration of the disease was recorded by him, my lord,
Yeah.
there is several discrepancies, Your Lordship.
That will be taken at the stage of final hearing, not at the bail stage. We cannot say that dying declaration has got these flaws and
At the time of trial, Your Lordship, the present appellant released on bail, Your Lordship. He
how
served
many
2
years you
years,
are in
6 months in
custody?
judicial custody.
What is the custody period you tell?
2 years, 6 months during trial, and now 8 months, Your Lordship. Almost 8 months.
Rohit and out to the room.
My lord, the age of the petitioner is 67 plus.
Put up after Durga Puja holiday. Yes.
Grateful.
Item 26.
May I please the Lordship? May I please the Lordship? I may be permitted from this. My lord, in this case, the petitioner is in jail custody.
Put up your
May I permitted to appear from this, my lord?
Yes, sir. Land Council, what is your good name?
Arun Kumar Behera.
Arun Kumar Behera. Okay. Yes.
In this case, the appellant is in jail custody more than 4 years, 9 months. The conviction under section 302 of the IPC. The conviction is for life.
That is the period undergone.
For 4 years, 9 years, 4 years, 9 months.
Just a minute. Just.
The two persons died. The deceased and his son also died.
No, doctor.
The dying declaration is there.
I will go to that. Just see, let him open. So, is it a case based on dying declaration?
Dying declaration.
Yes, ma'am.
What is that dying declaration? Marcus?
Exhibit 3.
Exhibit 2. 2.
My lord.
No, my lord. No, my lord. It's exhibit 3.
Yes, all right. Exhibit 3. Who has recorded the dying declaration?
PW5.
Exhibit master table 5.
Exhibit
PW5.
master. They come to that exhibit 3. All right. Tomorrow namo kon Parvati Kobat, Tommy ka namo Antarjami Kobat, Sasugar Kutu Anso. ଏ ତୁମର ଏ ଅବସ୍ଥା ପାଇଁ ଦାୟୀ କିଏ? ମୋ ସ୍ୱାମୀ କିରୋସିନ ଢାଳି ମୋତେ ପୋଡ଼ିଦେଲା। ମୋ ପାଖରେ ମୋ 2 ପୁଅ ଥିଲେ। ତ
ଆଉ କିଛି କହିପାରିବିନି।
ହଁ, କ'ଣ ହେଲା? ଅସୁବିଧା କ'ଣ? କହିଥାନ୍ତେ ଏତିକି ତ କହିଲା ମଞ୍ଜି ଜିନିଷ
During the time of occurrence, 2 sons were present, but they were not examined by the police, but they were not examined by the 2 IO, and they were not examined by the prosecution.
No, if we find that the dying declaration is truthful, believable, then
Yes.
Can we not rely on only this dying declaration to maintain a conviction?
Yes, ma'am.
Then
In this connection-
what is the flaw in that? Baki rest of the thing, she examine karni,
Yes,
soda
yes,
ko
ma'am.
final
hearing.
final hearing.
In this case, there is 2 dying declarations that have been recorded.
dying
Kindly have a
declarations?
glance. Yes. Kindly have a glance at evidence of PW12.
No, 2 dying declaration mean what is the other dying declaration?
The PW12 stated that during the course of investigation, ASI of police PK Goswami examined the deceased at SCB Kotak and
Mr.
declared
Counsel,
that
if you say 2 dying declaration, where is the other dying declaration according to you?
Which exhibit?
the other dying declaration has not been placed by the prosecution during the time of trial, but the PW12 categorically stated in his examination in C para number 2. Kindly have a glance. PW12, evidence of PW12 para number 2.
Yes.
During the course of investigation, the ASA of police P.K. Goswami examined the deceased at SCB and CH Kotak and recorded the dying declaration of the deceased. This is the said dying declaration of the deceased already marked by Exhibit 3/2.
Yes.
Here, the PW High Executive Magistrate deposed before the trial court that this, I have recorded the dying declaration. But the PW 12.
Mr. Counsel, this is the dying declaration is Exhibit 3.
Yes.
So it was recorded in the presence of the doctor,
Yes.
and it has been recorded actually by that executive magistrate, but
Yes.
in presence of the doctor has given the certificate and states that I examined the patient and found the patient can speak and respond so on so. So the certificate is there, and you cannot say that there is another dying declaration because he very well says that this is the same one. Exhibit 3 is the only dying declaration. Don't go to that technicalities. It is recorded by the executive magistrate. Doctor is present, associate professor, Department of Surgery, SC Medical College, and this is the dying declaration.
My lord, kindly have a glance. The examination process is part of PW 5, para number 4.
Those things you can argue at the final stage of argument on appeal.
Yes.
For the purpose of bail, that those things may not be relevant. How many years you are in there? 4 years only.
4 years, 9 months.
Come after Durga Puja holidays, we are adjourning the matter. After Durga Puja holidays, yes. And Mr. Kumar Behra, London Council, appearing through virtual High Court through Balasore after Durga Puja holidays. Yes, next.
My lord, stay realization of the fine amount, 50,000 fine amount.
Stay realization of the fine amount. That will pass the orders.
Yes, my.
Yes.
Item 27.
May I please, Your Lordship? Your Lordship, sir, last occasion I fought for the LCR. I've served already their copies of the deposition, Your Lordship.
You have got the copies?
Yes, Your Lordship.
Okay.
Your Lordship, this case rests upon direct
You
evidence.
are having the deposition copy with
Yes.
you? Yes. Yes.
Your Lordship, this case rests upon direct evidence. This is a case of road traffic accident which has been projected as a case of murder, Your Lordship. The petitioner is inside custody since 16/3/2022 and he has not been granted bail till date, Your Lordship.
No, it's all right. Who is that eyewitness?
Your Lordship, PW 6, 10 and 16 are 3 eyewitnesses. Your Lordship.
PW 6,
10 and 16, Your Lordship.
With the doctor?
PW 18, Your Lordship.
PM doctor?
Your Lordship.
Okay. What the doctor has stated?
Your Lordship, the evidence of the ocular evidence and the medical evidence.
Just a minute. The cause of death is due to hemorrhagic hypovolemic shock because of multiple organ puncture wounds, injuries and so on. So how do you say that it is an accident case?
Your Lordship.
The evidence of the eyewitnesses.
Your Lordship.
So and so, my son came, I asked him about the reason for so. He replied, okay. All on a sudden, a tipper vehicle being driven by the accused ran over my son. As a result of my son died at the spot. So the man was sitting in the outer veranda of the house, and his son came and he was talking with his son. And at that point of time, this vehicle came, and the most important thing is that you put the back gear,
yes,
and try to escape, and then dashed against the tree. And okay, what is the material to show that it's an accident? Because they say that you have got previous hostility with that person.
Yes.
whom-
Yes. PW 10 says, prior to 2 days, you have threatened to kill him.
Yes. Your Lordship, the case of
Thereafter this has
Your
happened.
Lordship, on the day of occurrence, there was a tussle between the accused and the deceased, Your Lordship. For which accused has lodged an FIR against the deceased. And the prosecution is alleging that the dispute was relating to land dispute. Your Lordship.
That shows that there was hostility between the two, and that gives the motive behind the commission of the crime.
Your Lordship, the eyewitnesses have stated to have dispute relating to land for which he has killed the deceased. But Your Lordships, no witness, including the IO, has proved as to which patch of land was in dispute. Your Lordship,
All these things are not relevant.
What is the size of that road? What is the length of that road and where this accident took place?
Your Lordship, the place of occurrence is suspicious.
Have you brought anything on record to that it's an accident? Suppose that deceased would be there on the road and it is a short road, how you are driving the vehicle, and if you put the brake, it would have been, the skid mark would have been
Yeah.
there. That shows that it would have been conduct. But you dashed it and you take the back gear and try
Which
to
ran
escape.
over the body
And
of the deceased.
prior to that, they are threatening, and on that day you lost the FIR also again. So all this effect has to be seen. It's not that it's a case of accident which has been projected as a murder.
Your Lordship,
It is basically is a murder. You want to project it as a action.
Your Lordship,
That's the case.
10 and 16 clearly have stated the accused put the reverse gear which ran over the body of the deceased, causing death of the deceased. But the PM report as well as the statement of the doctor shows that this is not a case of homicide. This is due to road traffic accident, and 6 fracture of ribs is present there. So, Your Lordships, if at all relying on the evidence of the eyewitnesses that the vehicle ran over the body of the deceased, causing the death, there must have been cross injury causing the intestines out, but no such injury is there, Your Lordships. And the prosecution ascribing the motive, Your Lordships, all the landed properties has been recorded in my name. No property has been recorded in the name of the deceased. And Your Lordships, the IO is stating that on the day of occurrence, the previous affair which was lost, that was due to intoxication. The deceased out of intoxication has assaulted.
PW10 has stated
Your Lordship,
that deceased was standing in front of the outer veranda of the house, and accused came in a big goods carriage vehicle in high speed, dashed against the deceased, against reversed the vehicle,
Your Lordship,
and ran over the deceased. So,
PW16 also.
PW16 also stated so, but it is contradictory to the statements of the doctor, Your Lordship.
Contradiction will see.
The involvement of the accused person is suspicious, Your Lordships. PW6 and 16 are
who is that person who has visited from the RTO's office? Anybody has gone there to see the spot of scene of occurrence?
Map, anything is there?
Have you examined it? କାରଣ ଯଦି ଡ୍ୟାସ୍ କରିବ ନା ସ୍ପିଡ୍ ହଠାତ୍ ସଡନ୍ ଦବ ତାପରେ ପୁଣି ବ୍ୟାକ୍ ଗିୟର କରି ତାକୁ ଚଢେଇବ, so again another mark would be there. Vehicle ଟା ଫାଷ୍ଟ ଡ୍ୟାସ୍ କଲା, ତାପରେ ପାସ୍ କଲା, ପୁଣି ଆଉ ଥରେ ଇଏ କରୁଛି, ପଛକୁ ଆସୁଛି, so ଯିଏ examine କରିବ that was so.
And Your Lordships, eyewitnesses are stating that occurrence took place in front of veranda. IO is stating
We
that
are asking you a question, you are going here and there. Anybody has
sir.
examined from this office to export to verify the spot visit and mark that what is the skid mark, all these things, because if the case is that first it was dashed, the deceased fell down, again that was back gear was given and taken, so there would be the skid mark accordingly. Hello? Say light ki examine the prosecution no.
Scientific officer.
कहीं से कितने नंबर सके थोड़ा को स्टडी करो.
This PW21, Your Lordship, but that has not, he was a charge sheeted witness but has not been examined by the prosecution.
If the report goes against in favor of you, then you would have proved that by calling for that. It is not necessary that the prosecution charge sheet witness cannot be examined by the defense counsel. So suppose they have not examined that man and you know that the report is in your favor, you could have taken steps also to prove that report by summoning the relevant witness. Now 3 eyewitnesses are there who have stated how the accident took place. First dashing, and if it would have been an accident, the reaction would have been otherwise. So, but you have not done that. You have again brought the vehicle in the back gear and again ran it over. So,
whose tipper was that?
Your Lordship, it was a tipper of some other person. But
You are not even a driver. You borrowed it.
Your Lordship, I am a driver.
But it's not yours. You have borrowed it to commit this.
Your Lordships, I am a driver who was working at the stone quarry.
The tipper was borrowed.
ribs are fractured, lungs and heart were punctured, spleen, stomach, intestine ruptured, containing blood, so and so. And cause of death was due to hemorrhagic hypovolemic shock because of the multiple organ punctured wound injuries and so on. So postmortem report was prepared. Put up after Durga Puja holiday. Yes.
Item 28.
He has been convicted under section 302, 307.
Lordship has been convicted.
And accused.
Yeah. What is the, you have been found guilty under section?
302, 307.
Yeah. So, how many years you are in custody?
3 years, 9 months.
3 years. Case of direct evidence, sir. Huh?
Direct evidence.
Who are the eyewitnesses?
PW 1, 2, 3.
1, 2, 3.
Yes.
Doctor.
Dr. PW 7.
Doctor?
7 is the PW. Dr. PW 7.
PW 7, doctor.
PW 7. PW 7 parke por asne. External injuries, lacerated wound, three lacerated wounds. Then another is occipital region, and third one is also present on the right mid thigh. Fourth one is mid thigh dissection also. Occipital bone or exit is a fracture injury. Pellet of firearm. So after his causing this injury, also fired at the deceased. The femur bone fractured into pieces at the exit point. The skin also lacerated. The pellet of firearm is lodged at the margin of the exit wound. Injuries are only said cause of death is due to brain injury due to the firearm. So, and your eyewitnesses have stated also like that. I accompanied the deceased to so and so, and accused persons came. So and so exploded bomb, abused in filthy language, and firing was made. And somebody hold the neck of the deceased, dragged him to a distance, abused him. Then Sankar Dali made so and so, and deceased Arjuna was forcibly sat on the unicorn motorcycle of the accused so and so by the accused also. Thereafter, Dharmananda drove the motorcycle with the deceased in the middle and accused so and so came. I returned to thereafter.
You are Bahana.
Yes.
Being accompanied by so and so. ତାକୁ କଣ ସେ ସ୍ପଟ ରୁ ନେଇଗଲେ
ସ୍ପଟ ନେଇ ଅଲଗା ଜାଗାରେ ମାରିଛନ୍ତି ଏବଂ ଆଙ୍କୁ ଥ୍ରେଟ କଲେ ବମ୍ ପକେଇକି ଏମାନଙ୍କୁ ଥ୍ରେଟନିଂ କଲେ
accused Arjuna sustained. Name of the deceased is
Arjun Baliar.
Bahana na Arjun?
Arjun Baliar.
Deceased is Arjun Baliar Singh.
Yes.
What about the other accused persons? They are appealed?
Yes, ma'am.
How many persons were facing trial? You only one.
All.
But what about the other person? You are only charge sheeted, or they were also charge sheeted?
Another person also.
Charge sheet ke jano na reach mo final front रे
ବାହାନକୋଟି ତାପସ ଜେନା ଶଙ୍କର ଦଳେଇ
ଏଗୁଡା ଏତେ ଲୋକ ନା charge sheet ହେଇଛି ସେମାନଙ୍କର କଣ ହେଲା absconding ଥିଲା ନା କଣ ଆଉ judgment ରେ ଆପଣ ଏକୁଟିଆ ନା ଅଛି ପରା ସେଇଥିପାଇଁ ପଚାରୁଛୁ. This judgment which has been before us, there only one accused name, that is Bahana Khati finds place. So if the other accused persons were also facing trial,
what happened to those?
then what happened? Their names is not.
Absconding.
ସେଇଆ କହୁନାହାନ୍ତି ଆମେ କହୁଛୁ ଆପଣ।
this honor to order to go. Kind of
କଣଟା ଏଇଟା କଣ ଅଛି?
Not the accused person. କଣ କହିବାକୁ ଚାହୁଁଛି? What do you want to say?
In the meantime, religion bail actually.
All right, so many considerations were there at that point of time. Apart from your detention period, you see, you are in jail custody since 2019.
Yes.
This bail order was passed in 2022.
Right.
So that was also one consideration apart from the evidence adduced to release of the co-accused. So many things have been taken into
Now
account.
you are convicted.
Now you are convicted, so
That will not help you.
the persons who took away the deceased from the spot, because the deceased was not killed at the first spot. First spot there was assault, but the statement indicates that thereafter Dharmananda drove the motorcycle. You come to this paragraph number 2 of PW 2 1B ସେୟା କହୁଛି 1B ସେୟା କହୁଛି ଯେ paragraph 2, the deceased Arjuna was forcibly set on the unicorn motorcycle. Accused Dharmananda by accused. Thereafter Dharmananda drove the vehicle and Arjuna ମଝିରେ ବସିଲା ପଛରେ accused ବାହାନ to the end. ହେଲା 3 ଜଣ ଟୋଟାଲ ମୋଟରସାଇକେଲ ରେ ଥିଲେ। ଧର୍ମାନନ୍ଦ ଗାଡି ଚଲାଉଥିଲା ମୋଟରସାଇକେଲ, ଡିସିଜ୍ଡ ମଝିରେ ବସିଲା and ବାହାନ ଅର୍ଥାତ୍ you were in the end ଅର୍ଥାତ୍ back ରେ ଥିଲେ। ଏହିପରି ଅବସ୍ଥାରେ he had already been injured by that time। ତାପରେ ତାକୁ ନେଇକି ଗଲେ, ସେତେବେଳେ କୌଣସି ଫାୟାରିଂ ହେଇନି, ଫଲ୍ସ ଫାୟାରିଂ ହେଇଛି ବୋଲି ସେମାନେ କହୁଛନ୍ତି। But when the postmortem has been conducted, the bullet was found inside the skull. Come to the postmortem report. Have you seen that PM report? That bullet was there very much. The paragraph 3, the pellet of the firearm is lodged at the margin of the exit wound. So there was what do you say? So the others accused persons liability, what they have done at the spot to the deceased Arjuna would be different from the roles which are attributed against you and that Dharmananda. କାରଣ ଆପଣ ହିଁ 2 ଜଣ ତାକୁ ମୋଟରସାଇକେଲ ନେଇକି ଗଲେ, ତାପରେ ଡେଡ୍ ବଡି ତାର ମିଳିଲା।
That he had a prior dispute with Arjun. You had a prior dispute with Arjun.
Arjun sustained one bullet injury on the forehead and the other in the thigh area of the body, was lying in a pool of blood. ଆପଣଙ୍କର ଏଇ ଯୋଉ ଇଞ୍ଜୁରି ଗୁଡାକ ହେଇଛି ନା, forehead ଏଗୁଡାକ ସବୁ ସ୍ପଟ ରେ ଯୋଉଠି ପ୍ରଥମ ଇନସିଡେଣ୍ଟ ଆରମ୍ଭ ହେଲା ସେଠି ହେଇନି ଏଗୁଡାକ। ଆପଣ ମୋଟରସାଇକେଲ ଦି ଜଣ ଯାକ ତାକୁ ମଝିରେ ବସେଇ ନେଲା ପରେ ସେ ଯୋଉଠି ଡେଡ୍ ବଡି ମିଳିଛି ଏଠି ସେଗୁଡାକ ତା ଦେହରେ ଏଇ ଇଞ୍ଜୁରି ତାମାନେ ଦେୟାର ଆଫ୍ଟର ହି ୱାଜ ଫାୟାର୍ଡ କନସର୍ଟ ତେଣୁ and that was the cause of death, those bullet injuries on the head, and according to the doctor, PW7.
Yes, serious.
After Durga Puja holiday, yes, next.
Item 29.
Please, my lord. Your the petitioner is a helper languishing in jail custody, my lord, since 2/5/2022, whereas, my lord, the cause of death was.
Have you received the deposition copy?
I've given. The cause of death was accident. Clearly, the PW14 doctor said the cause that is the accidental death. And my lord, that PW17, page 9, sir, judgment is said. The IO has stated in para 4 that he received the MBA accident report wherein it opined that.
PW3, 4 and 6 are the eyewitnesses to the occurrence.
Sir. PW7 has stated that para 4 that he received the MBA accident report wherein it is opined that the motorcycle was crossed under the tipper and the cause of accident is due to any other reason other than the sudden mechanical failure.
You come to the first eyewitness question,
Sir.
Doctor's evidence is an expert evidence. You come to the eyewitnesses.
Eyewitnesses are 5. That.
3 eyewitness will come to one of the eyewitness. PW3 person.
Sir, PW3, yes. Again. 3. I know the informant, I know the accused standing inside the dog. The occurrence took place on 1/5/2022 at Ghontapalli at the construction site. During that time, I was working as a driver under the Ramachandi Construction Company. The accused was also a helper of a highway truck, and the deceased Satyanarayana Panthe was working as a munshi in that company. On that, the accused and the deceased quarreled with each other during the evening hour due to some reason which I don't know. After that, the deceased went to the construction site where each was being excavated.
Earth was being excavated. Where
earth was being excavated. While he was also sitting over the motorcycle at the spot, the accused ran over the highway truck over him. At that time, I was at camp. Hearing about the incident, he went to the spot and saw the deceased lying on the roadside. The truck had ran over his leg. JCB operator Korna Dehuri, who was also present at the spot at the time of occurrence, told me that the accused ran over the highway over the deceased. I, along with some other shifted deceased to Contamal Hospital, but he was also declared dead there on the next day.
Same thing has been stated by other witnesses. PW4 has also stated that the deceased was talking over the phone and sitting on the left side of the road over his motorcycle, and you came in a highway truck in a high speed and ran over so and so. Now you are projecting this case as the accident. The wheel of so and so ran over the lower part of the body. He also sustained so and so. You accused then fled away from the spot with the vehicle in high speed. Yes.
Sir, the opinion of the doctor.
Schedule 5 is the manager of that company.
He has joined 7 days prior to the incident. The helper joined 7 days prior to the incident, and key was also handed over for temporary work.
There was a fight. PW1 tried to counsel between both of you, and you didn't agree. Thereafter, you have done this.
That was the allegation, sir. That was the allegation.
No, that is the evidence.
That was the allegation because prior.
That's the evidence.
Sir, evidence that prior to the occurrence, 7 days prior to the occurrence, he has also joined as a helper. And it is clear that the doctor said in the deposition, PW14, Dr. Mohendra Soy, that I have not mentioned cross-examination, he said, I have not mentioned in Exhibit 12 that the injuries are antemortem in nature. I have not mentioned in Exhibit 12 that the injuries appearing on the dead body of the deceased are due to homicidal, accidental or suicidal. The type of injury is possible when a person comes in contact with a heavy vehicle accidentally. I have not mentioned the date on which so and so. It is not the fact that I have not conducted the
postmortem. He has stated that I have examined the highway vehicle and found that the injuries sustained by the deceased are possible by that way. That is, yes or no, that he has stated that yes, it is possible by the highway, and what he has noticed, including crossing of the vein parts, fracture of the occipital bone, temporal bone, left parietal bone, all these things he have stated apart from lower and upper mandible. Now the question is, the doctor does not rule out that the vehicle can cause the death of the. Now the eyewitnesses have to be seen at this juncture. All the eyewitnesses have stated that he was sitting on his motorcycle and talking in his mobile phone. At that point of time, you are having previous enmity and you came in a high speed in that highway, dashed against that man who fell down, and as a result of
Dilip Pradhan is the real the driver. That day he was on leave.
When he was on
You are
leave-
not even the driver.
No, I'm
You
not.
took the key and
No, key was in the office.
Huh.
The key was at the office.
what? Why have you driven it?
Suppose
Why have you driven that?
Sir, any urgent requirement is
What is the
required.
urgent?
The excavation, maybe some excavation.
Maybe, no,
There is no
maybe.
question
Tell
of
me,
maybe.
tell us from the evidence.
that what is your accused statement? Your accused statement is na. Have you taken that plea that some urgent work was there? I was interested to take the vehicle, and that is how I went took the vehicle.
For that,
The entire thing is na micha kotha. So
Rather, the evidence is the witness says that he had never seen you driving the truck. First time you have driven the truck. And
well,
that-
7 days before the incident, he has
that's
joined.
there more of a reason that you should not have driven
But
the
there was no prior enmity between the two. Neither driver nor
There was. Evidence is there was. Wait.
after
there was no case of 302, sir.
yes.
Item 30.
Well, this resolution clear to 34 days delay in preferring the appeal. IR number 1408 of 25.
34 days delay.
My lord.
So you pay from your pocket 3,000 to the High Court Bar Association.
Or approved the Maganas.
IN number so and so, this is an application for condonation of delay. Stamp reporter has pointed out delay of 34 days, since it's a case where the appellant has been sentenced to life imprisonment. We are inclined to condone the delay. According delay is condoned. Admit call for the trial court record, interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copy to be supplied to the land council for the state. Yes.
Item 31.
May it please your lordships, in this matter I am through VC. My lord, on the last date, that is 24th of June, this matter was taken up, and my lord gave direction to file the certified copy
Yeah, have
of
you filed the objection to the delay condonation?
I have not filed that. Yes,
You intend to file or will condone?
will
it?
intend to file. I have written the letter to the.
Life
No.
conviction, bro. All right, we are giving you another opportunity, Lakon. The land council for the state seeks for an adjournment to file objection to the interim application filed for condonation of delay. Put up this matter. Kebe kon daw de havan.
My lord, in it short date, kindly list
1 week after.
next week.
All right, 1 week after 28th it will come. On 28th, what is your good name, Land and Council?
Ambrish Kumar.
Amrish Kumar. 28th of July 2025.
Item 32.
We are just coming within 2 minutes.
Item 32.
Item 32, I am
appearing
appearing for opposite party, State Bank of India.
I am appearing for the petitioner. For the last order, your lordship, it was ordered to verify any of the registry, your lordship, but no one has appeared for opposite party.
It's all right. If he has not appeared, then matter will be hard on merit because it's a for final disposal, I think. So there's no counsel. ठीक है.
Any date, your lordship, next.
Oh, you are not ready today.
Senior.
Listen, the registry has submitted a report, which is at clerk के तेरा से report तक. अच्छा, ये the registry has submitted the report that no one has entered appearance for opposite party number 5. Stop. The land and counsel for the petitioner, so also the land counsel for the opposite party bank, 6 for an adjournment. केबे रखियो अपन तो?
After 2 weeks, your lordship.
Maybe in first week of August.
Okay. 11/8/2025. Yes, next.
Item 33.
Yes. That affidavit has been filed.
Yes, sir, I'm filing just now.
For today. What you have written in your affidavit?
Let's see if
Copy has been handed over to Mr.
just
Mishra.
now I received a copy, but I have gone through it now.
Yes.
The
Anything?
specific question was whether the opportunity of hearing was given or not. Because the High Court directed that you give opportunity of hearing. Nothing has been mentioned about it.
A detailed order was passed, I think, on
Page 45.
4/7/25.
Page 45 is the order of the previous read, and your lordship subsequently passed an order.
4/7/25.
Yes, sir.
On the ground of so and so, submit that. Last
4/7.
time the matter was before this court in so and so in the petition challenge is over. Okay, within 30 days. In this operation to sell the model to the prospective buyers to public auction. In this court disposed of the and in the operative portion of the audit appears that land council has made a submission before the region when one-time settlement has been floated in 2011, which is still in existence, and it was open to the petitioner's company to avail such benefit if they are so advised. Let us further observe that in disposing of the case that in the case the petitioner filed an application to settle this one. In such event, the vice officer consider the same as per 2011 scheme and take a decision expeditiously, giving opportunity of hearing to the petitioner further order as passed to continue the interim order of particular decision is taken. Pointing out to the interim order, letter counsel and counsel will submit that even though as per the aforesaid order filed, the petitioner filed an application for settlement of the loan of, but no opportunity of hearing was provided to the petitioner, flouting the order of this payment was rejected on the ground of so and so. We are told that the order for known to the court. So that is how the Mr. Mishra.
Very specific question, very specific question
Yes,
was
yes.
put. 1 minute.
Yes.
Specific question was 2011 scheme, OTA scheme will be applicable in his case or not, or 2000 till 2009, whatever the outstanding is there, he will pay as per 2011 scheme. That was the instruction. You have written again on merits, so many things. What is the answer to that?
Page paragraph 5, my lord, and the read petition, page 49.
Merit we will hear.
No, my lordship's query, my lord. Yes, my lord. That's the opportunity was given, my lord. That's the page.
No, the first thing which we asked, whether 2011 scheme.
Two questions, my lord. One question is opportunity whether it has been given
Yes.
or not.
Next question.
That's opportunity has been given. And the next question, my lordship is asking for.
How do you justify that? Merely saying so?
No. That's the opportunity. Annexed 17.
Please listen to us.
Yes, no.
As per the order of this court in the earlier division bench,
Yes, no.
there was a specific order that, and in terms of that order, he filed an application.
Yes.
So the question is, if you have given the opportunity, then you would have issued notice to him that on such and such date you appear.
Page 49. To appear. The petitioner has annexed this annex 17, my lord. My lordship can have a glass. Yes.
Let us see them.
But that part you have not said anything.
No.
Whether 2011 scheme you are agreeing or not.
Okay.
Yes, my lord. At the paragraph 8, my lord.
Annexure 17, you say 17 is dated 33/2019.
Yes.
You are required to apply for OPS in the prescribed format along with the initial deposit of rupees as per the order of the so and so. You are at liberty to come to the branch and place your views. It should be heard and considered on its own merit. We are encouraging to so and so. That tapre kon hala?
My lordship, the first the order was passed. My lordship, it is.
ନାଇଁ ସେ ଫାଷ୍ଟ ଅର୍ଡର କଲେ ଆପଣ 33 ବି ଆପଣ ଓପନ ଥିଲେ ଯେ ତମେ ଯଦି ଓଟିଏସ୍ ପ୍ରପୋଜାଲ ଦିଆଯିବ then we are ready to consider. That is the
Yes, not the
that is 33/2019.
34, my lordship, the contention of the loan council for the petitioner. Loan council for the petitioners further submitted that a one-time settlement scheme has been floated by the corporation that the petitioner company may be permitted to avail the said benefit to settle the loan account. And then, my lordship, on the spur of the moment, it was asked, and I have also said that that's existing. And then, my lordship, that the order was there in the paragraph 5, page 45. Concerning the above, we dispose of the requisition with an observation that in the case of it's filed an application to settle the loan account within a period of 2 weeks from today. In such event, opposite part number 1 and 2 shall consider the same as per the 2011 scheme and take a decision that as expected as possible within 4 weeks. Within a period of, is not reading that. Yes, within a period of 4 weeks thereafter. What happened there, my lord? It's filed one simple application without the format. Then we, on at page 49, on 30th March 2019, we have given this letter that you prescribed format, you apply in the prescribed
Then he
format.
applied in that format. Right.
Yes, format and deposit the initial deposit as per the scheme,
Then
and the administrative charges.
Then you pass
and
this
as
order.
the order of the Seminole Court, and you place your views and which will be heard and considered on your own merit.
Right. So what you have passed the order, you come to that order dated 13/8/2019.
Yes, no. And prior to that, my lordship, I have annexed one document here.
আমি সেই অর্ডারটাও যেটাও চ্যালেঞ্জ করছেন সেই অর্ডারটাও আসନ୍ତୁ যেটা 13/8/2019 annexure number
Yes, no, page 57, the annexure 21.
ସିଏ ଆପଣଙ୍କୁ ପ୍ରପୋଜାଲ ଦେଲେ ଏତିକି ଟଙ୍କାରେ ଆମେ ଆପଣ କଣ ଇଏଟା କଲେ ଅର୍ଡରଟା ଦେଖୁନ କଣ ଲେଖିଛନ୍ତି
Order, my lordship, why this is the plant and machinery financed by the corporation is hypothecated to corporation are missing and mortgage premises has been let out to unauthorized and which amounts to an act of malfeasance. My lordship, without permission of the corporation, the petitioner has sold the plant and machinery.
ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଆପଣ ଏଇ ସ୍କିମ ରେ 2011 ସ୍କିମ ଅନୁଯାୟୀ ଆପଣ ସେଟାକୁ ଇଏ କରିବେ ଆପଣ ଏଗୁଡାକ ଯୋଉ ଏକ୍ସଟ୍ରାନିୟସ୍ ଜିନିଷ
No, my lordship, I have filed one that OTS application, my lordship, OTS provision, my lordship, I will see in the.
Why don't you answer simply whether
I'm coming, my lord. That's
ବର୍ତ୍ତମାନ ମଧ୍ୟ ସେମାନେ ଯଦି
directed to consider the OTS as per the OTS 2011.
Your answer is no. Isn't it?
I'm coming.
What you will do?
I have filed one.
Now the unit has already been spoiled and it will further all these machinery will go in this way.
No, they have sold, my lord, without the permission, my lord. And my lordship, I have filed the provisions of the
OTS, my lord. That's affidavit I filed on 12/5/2023, my lord. Where the
Mr. Naik, our question is very simple. Kindly see 4/7/2025 order. 4/7/25 order, last paragraph. What is your answer to this? Thereafter, we will proceed on merits.
That's no.
You see, last paragraph.
OTS
Present counsel for OSFC.
ଆପଣ କହୁନାହାନ୍ତି ଯେ ମେସିନାରୀ ଗୁଡାକ ଏଇଆ ତାର ରେଟ୍ ଏଇଆ ଆପଣଙ୍କୁ ଏତିକି ଦବାକୁ ପଡିବ ଆମକୁ ଆପଣ ରିଜେକ୍ଟ କରୁଛନ୍ତି।
That mortgage property has been sold, my lord. That's the malfeasance and without permission of the authority, my lord. And only on the rent, and he has capacity to pay the because the as per the order of the Honorable Court, the rent that the seized unit, my lord. And as per the order of the Honorable Court, the rent was deposited in the separate account, in the fixed deposit account, my lord. And that's there. And my lordship directed the OP3, who has been on rent.
You see,
He did not come into the court.
the machineries were there. You just finance those from your corporation, finance those.
Yes.
Then the unit was seized.
Yes, ma'am.
Then it was found missing. So the presumption is that he has sold it.
No, he has sold at the without permission of the authority, which is the mortgage property, my lord.
How do you say so? Some properties you have mortgage, you have financed it,
Yes,
right?
Yes.
Then the unit was seized.
Yes, ma'am.
Then the keys with you.
Yes, ma'am.
Thereafter, the machineries were found missing. So how do you presume that they have sold those properties? When you seize
Prior to that, it has been let out to the tenants, my lord. Prior to seizure. And when
I'll just speak five sentences, man. But they have never financed for the machineries. Only they have sanctioned the loan for the purpose of setting up the factory and all that. They have not financed anything for specifically. Guarantee was given. But here I have written a letter in 99 to settle the account. They settled it for 28 lakhs. Out of 43 lakhs, 28 lakhs. I agreed to pay that amount. I have paid that amount. Only 1 lakh amount was due. I said, I have written a letter in 99. I'm selling the machineries to clear up the dues because I'm going to pay the entire amount. I have sold and paid the entire amount. No objection was there at any point of time. After paying the same, they said there is a delayed payment interest.
That also you paid.
That also I paid.
Yes.
Sir, after the delayed payment interest was paid, they seized, attached everything.
So with your permission, if they have sold, with your permission.
No, without permission.
I have written a letter, sir. Yes, sir, letter is there.
Something was there.
Even if no permission,
that's not on record.
Sir, even if without permission, payment has been made.
We heard that day.
Yes, entire payment has been made.
That's on record.
We heard that day very extensively. Thereafter this order was passed. And without answering that,
here, my lordship, the petition counsel.
no, let us confine to that order first. Let us be satisfied on that. What are you trying to answer?
Answer, my lordship.
You are going to the merits. Yes or no? Yes or no? You tell us.
OTS cannot be settled. That's the affidavit.
Court likhichanti apna dekha.
Para 8 last line.
Again, you are bringing this, that, so many things.
OTS cannot be settled, my lord.
But he cannot say now because he has agreed before the High Court that he will settle it in 211.
No, we have considered and rejected.
No, you cannot reject
on 3 grounds, my lord.
Sir, you have
that
to
cannot be adjudicated in the read petition. That the judgment I have said.
We know that you have rejected.
Yes, my lord.
Thereafter only this order was passed.
Yes, my lord. This order, my lord.
Now, where have you said?
Earlier,
no, in the affidavit, where have you said that we are not
para
going
8
to
last
consider?
line also. Para 8 last line. OTS cannot be settled, my lord.
That was earlier. Are you not following this? But that was rejected earlier. Thereafter, we have stated that you are to take instruction.
Yes.
That.
That's the instruction. OTS cannot be settled, my lord. Because he has paying capacity, my lord.
Paying capacity doesn't mean that you can
yes,
arbitrate a person like
the
this.
Supreme Court, my lord. Big no judgment, my lord. Yeah, 2022 Supreme Court. I will also.
Financial operations health.
Financial cited the judgment. Justice Gowda division directed.
No, so that's the judgment.
Because the rejection was bad.
No, that's the judgment. Delay period has been delayed on the ground of delay. They have been rejected, and that apart, they have encased the DD, that initial amount. For this reason, this Honorable Court held that no. On the ground of delay, you cannot, after encasing the initial amount, on the ground of delay, you cannot reject. That's the judgment. Now the judgment has come in the
paragraph number 10, rather you have stated that since we have earlier rejected it, the OTS proposal in 9/8/2009, come to paragraph number 10.
Yes, sir.
On this ground, therefore you are not interested to settle the loan account. That is the words have been used here. So there was a specific direction in the earlier order that was passed. Come to that order again once again.
As per the 2011 scheme, and I am showing the provision of the OTS I have filed that the rules, my lordship, the 8-page affidavit H/1, that the provision has been specifically mentioned. Normally, the benefit of OTS should not be extended to the case of willful default, fraud, and malfeasance committed by the unscrupulous borrowers and guarantors. That is the ground below. Then the 5.1, deposit of recovery amount charges, documents such as audited balance and PL accounts for 3 years, which has not been submitted. That's the last ground. And of the 3 grounds that has been rejected, and that's rejected as per the provisions of the OTS policy 2011.
How can you bring his case within the bracket of willful defaulter if he has kept on paying the amount?
No, he is not paying, my lord, for since long.
28 lakh.
That's 1981, the loan is granted for 9 years.
Amount has been paid.
80 to 89, the loan, number of loans have been granted, and no payment, my lord, since long. Because my lordship, as per my lordship's order, the some payments have been made 17 to 21, my lordship, by the OP3 paying, even if the interim order it cannot be evicted.
But since we were not interested to settle it, then we will hear and merit our.
Yes, yes.
That is the reason why we urgent.
Yes, earlier that was also by Honorable Justice K.R. Mahapat.
No, it's all right.
Earlier directed to whether a matter can be settled or not. That was the instruction.
It's all right. Now the affidavit has come. As for the order dated 4/7/2025, the Learning Council appearing for the OSFC.
No sentences that opportunity was given. No sentences.
As that will be considered in the final year, as filed an affidavit by the Director of Industries.
Now in charge of
and who is now in additional charge of Managing Director of the OSFC. In the aforesaid order dated 4/7/2025, we specifically asked the Learning Council for the OSFC to obtain instruction regarding providing opportunity of hearing to the petitioner while passing the impugned order under Annexure 21, and further to obtain instruction whether, as per the OTS scheme of the year 2011, the corporation is ready and willing to settle the loan account of the petitioners up to 2019. In the affidavit, nothing has been stated about providing of opportunity of hearing to the petitioner while passing the impugned order by Annexure 21. However,
provided is not sir, what do you
however, just a minute.
49.
However, it has been stated in paragraph number 10 of the affidavit that since in the meeting held on 9/8/2019, it was decided to reject the OTS proposal of the petitioner under OTS 2011 scheme as on the ground of malfeasance, willful default, etc., the corporation is not interested to settle the loan dues of the petitioner under OTS 2011 scheme up to 2019. The affidavit is taken on record. Copy of the affidavit has been served on Mr. Mishra and Senior Advocate appearing for the petitioners. Put up this matter. Kebe Rakiva Kunt, final hearing.
Next week, any date, sir?
Kuntu upon.
23rd. 23rd.
25. Put up this matter on 25th July 2025.
Right.
Interim order dated 24/12/2000.
Interim order, my lordship, so one submission, my lordship directed the OP number 3 to appear.
It is continuing till
No,
since
my lordship.
2019. Why,
Just-
when we are fixing for final disposal, we will back at
Yes,
that order.
lordship,
Yeah, all right.
he is not complying the order.
We'll see
And
that.
interim order is shall not be evicted.
We will.
And
solve.
the
You should
since
have moved application. There is no application for eviction.
Sir, 28 को रखो
no,
ना.
evict shall not be evicted. That is the interim order.
28/7/2000.
And my lordship directed the issue notice, but he is not appearing nor also paying.
We'll see on that.
Next. 34.
Item 34.
34. She can add the one.
No,
To get
38.
ready.
28. Yes, Mr. Roth.
If you have some time to get ready with the matter, can it be next week?
Oh.
Can it be on any Monday?
She approves me that she is not ready.
Miss Suvalakshmi Devi, London Additional Standing Counsel, 6 for an adjournment for 1 week or next week.
Monday.
Oh, next week you will do it. Huh?
Monday, sir.
Monday.
Monday.
Monday. Don't put in it.
Monday.
She suggested me for
All
Monday,
right.
so I agreed for that.
Next
Sunday
week,
would be there to go through the file.
Mr. Roth, Lund Senior Advocate has no objection. With this matter on 21st July 2020.
Monday.
Monday file upon? Yes.
Much.
My petition can be referred. I am appealing for the university.
Acha, Land Council, Mr. Purohit, Land Council appearing for the कहाँ पाई?
University, Sambhalpur.
Sambhalpur University opposite party number टा कोई दो ना दी?
24, 25.
Opposite
25, 26.
opposite party number टा देखिए.
25, 26.
25, 26 is present. Yes.
Your Lordship, in item number 35, I'm appearing for the petitioner, Your Lordship. However, counsel, testimony is held. The arguing counsel is held up in another court. If Your Lordship places the pleadings are complete, the matter may be put up next week for all hearing, Your Lordship.
4 occasions she has taken.
Lordship,
You have been taking.
yes, Your Lordship, I had taken, Your Lordship, but only
You are for the petitioner or opposite party?
petitioner, Your Lordship. There's already an interim order.
Tell us a date, just.
Next week.
See the last repeated dates मिला. 4 occasions he has taken time.
Next week, Your Lordship.
कौन करे तांगा senior कौनसी court held of ये चंदी वाली submission होती.
Held up for also
You are also a senior, be liberal to the associate. Yes.
Get now you get ready yourself. Next time no matter.
JRF order को challenge करते हैं. In the meantime, during pendency of this case, they have given a supply. Because JRF has passed the order directed to give power supply to my residence. I am a domestic consumer.
There is already a temporary connection in their favor, Your Lordship. That's why. 1 week.
No, it is a case, my lord, where the licensee is trying to remove the existing structure in time of OCV.
Date.
Next week, Your Lordship.
21 तारीख है.
21 तारीख तक कैसे होगा? 23 तारीख तक. The Land Council for the petitioner 6 for an adjournment. Land Council for the opposite party has no serious objection. On consensus of both the parties, list this matter on 23rd July 2025. Interim order dated so and so shall continue till next date. Yes.
Item 36.
Received the instruction. I'll be replying.
Counter file करना है दी.
No, Karu. I have received the instruction.
Look, the Land Council for the petitioner is present. You have received the instruction. The Mr. Rayaguru Land Central Government Council, Senior Panel Council submits that instruction has already been received and counter will be prepared and file it within
3 weeks.
3 weeks. Put up this matter August 2nd will get of copy of the counter affidavit we served on the land council for the petitioner. In the meantime, is at liberty to file the rejoinder affidavit. Yes, next.
Item 37.
On the behalf of Mr. Arjuna Magamala, we are appearing from bank, opposite of the bank. We will serve instruction 2 weeks time.
Instruction 2,
2 weeks time.
who is for the petitioner, Mr. Swamjit Raut and S. Mahanti.
Morning, he was mentioning.
Peter.
Before we taken up.
Expedite disposal of the section 14 application and handing over the possession. The details of section.
Where is he was mentioned? Mention korthile koda gale.
Online he mentioned saying that it may be taken very urgent.
Na dida diye. Select the non appears for the petitioner, the land council for the bank 6 for an adjournment. So, যেহেতু সে urgency বলে মেনটেন করলে বেশি সময় দিয়ে মানে 28 তারিখ রখুଛୁ 28/7/2025. Yes, next. এই যে রিফ্লেক্ট হଉଛି তো কোন আইটেম চালিছি বলি হ্যাঁ ডিসপ্লে বোর্ড রে হ্যাঁ ঠিক আছে.
Item 38.
Lordship, I am for opposite party 2 to 4. Your Lordship, praying for an adjournment. Senior is out of session.
Section 14 application has been rejected. I am to the bank.
No, right. Then you can challenge it here. It's all right. What do you want, madam?
It may be taken up next week. Monday.
Next week. Next week is all right. So you are for that borrower?
Borrower.
Yes.
There is no stay, nothing.
Actually, what happened, I'm not arguing on merit because I adjourned. But the bank officer was told, allow me to sell one of the items. There are 4 or 5 items, item property, so that I can repay the entire amount. The bank officer in good faith said that so reconveyance deed was executed. The reconveyance deed contains the entire, all the items, 1 to 6, because there was a one document of mortgage. So after it was executed, he said, no, I'm not going to pay. So he again filed a 14 application. So 14 application, the law says that a person in whose favor the reconveyance deed has been executed, he must show that he has liquidated or paid the entire amount.
Yes.
No document he produced regarding the payment. Therefore, 14 application was filed. He intervened and said that in view of the reconveyance deed, there is no mortgage, you cannot sell the property or attach the property. So it is neither here nor the bank officer, actually the person who was in good faith agreed, now he is in a suit.
And money matter, no good faith.
Madam, next week. All right. So 23rd, Mr. Mishra.
23rd.
Land and council for the opposite party number. कितने number अपन opposite party number 2?
2 to 4.
2 to 4. 6 for an adjournment. Mr. S.Mishra and senior advocate is present for the petitioner. Put up this matter on 23rd of July 2025. 23/7/2025. Yes.
Item 39.
File the counter.
Mr. Bari, you have not filed the counter affidavit. You will not file.
In this case, I seek time to file counter affidavit. You have received the same.
Instruction पाइए ना नहीं पाई ना
Last occasion 6 times to taken to file.
अपन last occasion ने कौन से time नहीं थे लेकिन पूछे हाँ ठीक है जा अपन नहीं थे केबे रखिवा काउंटर एफिडेविट के फाइल करियो कोन दो
2 weeks after 2 weeks.
Last.
मिस्टर पाल डेप्यूटी सॉलिसिटर जनरल आउ का नाम लिखा वो कोई दियो
Mr. S.S. Kashyap.
अच्छा काश्यप सेंट्रल गवर्नमेंट काउंसिल
Senior bank council.
senior panel counsel, appearing on behalf of the opposite party, seeks a more time to file counter affidavit. Put up this matter in the week commencing from 11th August 2025. Counter affidavit be filed in the meantime, serving copy on the land council for the petition. Yes.
Item 40.
Item 40, Your Lordship, and we have instructions to apply for the respondent.
You are supposed to file Wakalatnama.
Opposite partner for Your Lordship, but due to the inconvenience of the personal difficulty of the opposite partner 4 itself, we could not collect his Wakalatnama. We grant 2 days, Your Lordship. In the meantime, we'll collect the Wakalatnama and file this.
On behalf of the petitioner, madam.
The land council for the petitioner is present, and the land council, Mr. Ruparekha Jena, land council appearing on behalf of Mr. El Maharana, submits that the Wakalatnama will be filed by next week for the opposite party number 4. Stop. List this matter in the commencing from 28th of July 2025. If the Wakalatnama is filed in the meantime, the same shall be kept on record. Please, Sahoo, Hon'Ble, boxes.
Password.
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 Really.